Perhaps I can ask a question of Sergeant Strathdee here. Is it the policy of the police force upon the arrest of someone whom you believe may have made a substantial amount of money to then report them as a person who should be examined by the income tax people?
Yes, we have done that in the past. Basically, from our investigation of the bookmaking offense, we have been able to ascertain the volume of money that this particular individual is reaping from this act. We have no information as to what income tax he may or may not have paid, nor do we ever learn that. But if he's making a sizable income from his bookmaking activities, and I'm talking in the area of $50, $100, $150,000, yes, we do notify Internal Revenue. The results of their investigation and our information we never do learn about other than reading about it in the paper.
So you're saying that you can't then get any kind of access to the income tax forms and you leave it in their hands once you raise it with them?
That's correct. We have no access at all to the Internal Revenue files.
Okay. I think we better turn now to a different issue, that being prostitution-related offenses. Since the abolition of the old Vagrancy C provision in 1972, we've had some important decisions come out of our Court of Appeal and also the Supreme Court of Canada, in Rowland and Hutt. And I'd like to turn and ask Peter what he thinks are the major significant developments in that area of the law, and to what extent that has affected his ability as a prosecutor to put together a case.
It's made it somewhat more difficult of a Crown to prosecute soliciting cases, in particular as a result of a Hutt decision, which says that soliciting means basically pressing or persistent conduct coupled with an offer of an act of sex. The Hutt case also stands for the fact that a motor vehicle is a private place, so an offer by a woman in a motor vehicle, which frequently happens when there are undercover police officers used as decoys, wouldn't constitute soliciting. As a result of these decisions, I find more defense counsel and more accused persons are pleading not guilty and fighting the case on the issue of whether or not the conduct constituted pressing and persistent conduct. With respect to the question of public place, I find now that since the interior of a car has been found not to be a public place, the evidence of the police more frequently is that the woman shouted something through the window. So the prostitutes are helping us along with the law. With respect to persistent conduct, there's some disagreement as to whether or not the persistence can be sequential, that is, relating to different people, or it has to be with the same person. The philosophy behind the law, I believe, was to just to prevent public inconvenience, and some defense counsel are arguing that means that a woman has to pester the same man 3 or 4 or 5 times before she can be accused of being guilty of pressing and persistent conduct. There's one decision that I'm aware of, Regina and Tayo, when I was unfortunately the Crown on it, and I believe it was under Judge Purvis ruled that was the case, that the persistence had to relate to the same person. And if a prostitute accosted 5 or 6 different men in a row, then that didn't constitute soliciting. There's another decision, however, the Queen against Donalda Stevens. I think Brian Greenspan acted on that one in the Court of Appeal, and that's some solace to the Crown because although it's not as clear as it could be, it does state that if the evidence is that a woman approached several men sequentially, that can constitute pressing and persistent conduct. So that's a case that I rely on frequently now to obviate the argument that the woman has to approach the same man.
Your Honor, with these decisions that have come out, can you indicate to the defense lawyers who practice in this area what common weaknesses you see in the Crown's cases that come before you, and what might be fertile areas for the defense to look at?
You're talking now about prostitution
Yes.
cases or soliciting cases. there has been one hole blown in the wall a mile wide by the Hutt decision. I think that defense counsel need not look any further than that. In most cases, the Crown cannot prove the importuning, persistent, pestering, annoying type of conduct required to constitute soliciting. And most of the Crown's cases that fail, in my view, fail for lack of proof in that area. There are other side areas, one of which was mentioned by Peter a few minutes ago concerning the fact that the offense did not occur in a public place. And I suppose there's always the accused who gets into the witness box and says, well, I wasn't there, or I didn't perform the conduct complained of, and there's some sort of mistaken identity. I suppose general defenses along that line, which apply to any criminal charge, would apply to a soliciting charge. I have found that since the Hutt decision, there has been a great decline in the number of convictions in cases where the accused has pleaded not guilty and contested the matter. Of course, you're still going to get the great multitude of persons charged who wander into the courtroom like sheep and who want, quote, to get it over with, unquote, and who will plead guilty to anything. Just they want to know where they sign and what they have to say just so they can get out. And obviously there are going to be a lot of convictions where pleas of guilty are entered. The Crown also has been having some success by searching all of the women charged with soliciting, and frequently as the result of those searches, the Crown or the police find various weapons such as knives, razor blades, cans of mace, etc. And of course then a backup weapons charge is usually laid in those cases to supplement the soliciting charge. Finally, there is an additional problem or occurrence that happens on the border in Niagara Falls and in Windsor, the areas adjacent to the United States. It frequently happens that many, if not most, of the accused persons are residents of the United States. And what happens there as a matter of practice is that when arrested, they are detained and then released on a cash bail, the most common amount I have seen being $100. Of course, when the matter comes on before the court, the accused does not appear, and that's the end of the cash bail, which eventually is estreated to the Crown. The accused, of course, is not heard from again until the following week when she reappears, this time bearing another name and another set of identification papers supporting the new identity. And one final matter arises on the border. Frequently, the police there turn the ladies in question over to the immigration authorities, who go through the paperwork and procedure necessary to have these persons deported. And in due course, they are deported, but as I previously indicated, they're back the following week and usually can't be recognized in any event.
If I could interject, one other thing I wanted to say as a result of Hutt, an interesting defense I've seen advanced twice so far. It hasn't been successful, but I think it could be under the right circumstances with the right judge or the wrong judge from the Crown's point of view. But I've seen situations where after an undercover policeman gave evidence that such and such a woman, the accused, approached him, say, 5 times on the street or in a bar and offered him sex for money, the defense counsel will put her on a stand, and the examination in chief will go something like this. What do you do for a living? I'm a common prostitute. And where do you normally work? On Yonge Street. And are you familiar with the Hutt decision? Yes, I've been told what it means. And as a result of that decision, have you changed your pattern of conduct in your work at all? Yes, I never approach a man more than once because I know I can be arrested. And as I say, it hasn't worked yet, but I think it might.
Let me raise two questions, and I'll just invite general comment for the moment. It's been my experience as an observer in places like bail court in College Park, where the Crown attorneys haven't been nearly so practical as they may be in His Honor's jurisdiction, and are asking for detention orders on women who are picked up who are clearly from the United States. And that practice goes on, and so these women are sitting in custody for periods of time. Is that is that a policy in the Crown Attorney's office?
No, I wouldn't think so. Without wanting to criticize my brother Crayons, I think that almost can amount to harassment. If I'm in bail court, and I'm not these days very often, but I would be inclined to just ask for a cash bail, perhaps $500 if they lived in Buffalo or Detroit. I certainly don't think it's a policy, and I don't think it's something that should be encouraged.
Let me also throw out one other thing. The Crown attorneys are fairly creative, it seems to me, when they come to coping with decisions like Hutt, and there's been an increase in the number of charges that really ring, let's say, in loitering, in a manner that obstructs. And they're now trying that as opposed to soliciting. Your Honor, is that your experience in your court, that there's an attempt now to get around Hutt by different series of charges? And are they successful?
That happens frequently in a great many areas of the criminal law. For example, when the Crown couldn't get convictions for an indecent stage performance under Section 163 of the Criminal Code for various exotic dancers, the Crown abandoned that section and moved over to Section 170 and began charging them with being nude in a public place. If they can make the facts fit the section they're moving to, they can get a conviction. To some extent in those cases, however, the Crown is trying to fit a square peg in a round hole, and it becomes very difficult for the Crown to establish sufficient facts to support the new charge. And I would think that the Crown would have just as much trouble on obstruction charges in the example that you mentioned as they would have on the soliciting charges.
Lou, do you have any comment in that regard?
Well, a couple of stories maybe would be apropos here. I remember a judge who was appointed some years ago, it's another Tupper Bigelow story, had the pleasure of being broken in by Tupper, and they were sitting in the old Sea Court together. Needless to say, in those days, what is now 23 saw a long progression of, I think the expression was hookers walking back and forth. And she'd come up, and it was her first offense, and Tupper would say, well, on this one here, you give them a $25 fine. Another one would come up, and that would be her second offense. Well, that's a second. He says, you got to give her a $50 fine. Next girl, third offense, and he'd say, well, this one here is clearly 30 days. And this went on for a month. Finally, this judge, who shall go nameless, leaned over and he said, by the way, Tupper, he says, when do you use the suspended sentence thing? He says, only when you're not sure they're guilty. Now, if I could make a couple of comments with respect to Hutt, it seems to me, and I borrow this from my wife, if she has to be persistent and pressing in her importuning, she ain't worth it. And it further seems to me that, borrowing a phrase from another area we're going to be dealing with later, the Supreme Court of Canada, in deciding Hutt, I think was really giving expression to what is a prevalent community standard today. I know there is draft legislation now which is intended to virtually do away with Hutt and perhaps bring us back to the old status. I don't think it will work, quite frankly, because I think our society has progressed to the stage where the offense, which was once called Vag C, was not deemed to be of sufficient importance to tie up the amount of time, effort, and money that it did. And I think the standard in our community remains that way, and I don't think that the future will show much progression in that area of the law. Of course, I've been wrong so many times before, I'm probably wrong again. But I think that would be my feeling on the matter. And that expression of a series of judges is a clear indication, at least to me, that that is not one of our pressing problems. It's reminiscent of a remark that was made to me at the height of the constitutional debate and the strike that was going on then. An editor of a local newspaper said to me, the mail can't move on time and they're worried about a constitution.
Let me address one other question to you, Lou. There have been a series of decisions dealing with areas like, can a man be a prostitute? Is the person who solicits also guilty?
The death knell
Or the
of
person who
male
is soliciting?
chauvinism.
Yes,
Yeah.
hopefully.
Well, it seems that if we take Chief Justice Howland's decision at face value, and there's no reason not to do so, that yes, a male can be a person who solicits, and consequently would come within the ambit of Section 195.1. The trouble is caused by the word prostitute in that section. If we look at the normal dictionary definition of the Greater Oxford English Dictionary, it deals in terms of a prostitute being a female. But given women's lib and again the progression of the community standard, if you look at some of the American dictionaries that have been published in the last 10 years, you will find that gender is not utilized in the definition of prostitute. And it may well be that courts will start giving expression to that new prevalent feeling, and it's conceivable that males will be deemed prostitutes. There are indeed decisions where they have been so deemed, and I'm thinking of the situation of what is commonly referred to now as male prostitutes, in drag or out, as the case may be, who have indeed been convicted. The law today, I think, is settled in Ontario by, yes, I do look at a case every now and then, by Di Piaula and Regina and Palatix, a decision of the Court of Appeal for Ontario composed of the Chief Justice, Mr. Justice Brooke, and Mr. Justice Martin. The judgment was written by Chief Justice Howland. And I think that decision should be read with some care and detail, because apart from the very simplistic statement that males may solicit within the provisions of 195.1 and the fact that they may be prostitutes, there is some considerable time spent in detailing the nature of the constituent elements of the offense and their basic meanings. It's a very well-reasoned, very carefully reasoned judgment, and one of the statements that it makes, for example, is that prostitution is not limited to sexual intercourse, and I think that really takes the law in this area a far step. I know in common parlance prostitution has been referred to in many realms. For example, even about lawyers, it has been said that they prostitute their principals for money. But be that as it may, I think this judgment gives a very clear expression to the entire area in which we're concerned and is of some note for all of us. In addition, I think that it's only sensible, if we look at it in terms of our modern society, that the section should be framed as it is, because the ill effect which it is intended to deal with is the solicitation, the importuning, if you will, the consistent and pressing conduct. And surely it shouldn't make any difference whether it's the male importuning the female, or another male for that matter, or vice versa, or again female to female.
And that would mean that the person soliciting the prostitute is guilty of the offense of soliciting on the reasoning of the case.
Or indeed, if we take the other judgments that have come out recently, the male may himself be a prostitute in the true sense. And then the importuning is twofold in that respect. I don't know that I would want to carry it any farther than that, because it may well be the law is in a state of flux. Although, frankly, I don't think so. I think that the Chief Justice's decision will stand for some time, and I think it's a very well-reasoned one, if I may say so.
Your Honor, you have some comment.
Yes, as far as I am concerned, the Regina and Di Paola case referred to by Lou, which is reported in, I believe, 1978-43 Canadian Criminal Cases, second series at page 199, is binding upon me as a provincial court judge, and accordingly I follow it because of stare decisis. There is, however, a contra decision recently pronounced by the Court of Appeal of British Columbia in the case of Regina and Dudak, D-U-D-A-K, reported in 1978, volume 41, Canadian Criminal Cases, second series at page 31, where there are conflicting decisions by courts of appeal in different provinces. Ultimately, the matter will have to go to the Supreme Court of Canada for determination, and that indeed was what happened in the Hutt case. As I have said, I will follow the Ontario Court of Appeal as I am required to do. My personal views on the matter are as follows. I recognize that out there on the street there are a great many male prostitutes, both heterosexual male prostitutes and homosexual male prostitutes, and they are out hustling a dollar just as actively and aggressively as their female brethren.
Sisters.
Or sister, yeah. However, if they approach a customer, and if a male customer is a John, I suppose a female customer is a Jane. If they approach a customer and use persistent importuning, soliciting conduct towards that customer, I do not see how the customer, merely by accepting an offer made, can be said to have committed an offense under section 195.1 of the Code of Soliciting. However, I feel that the male who is guilty of the importuning conduct and who otherwise complies and fulfills the various requirements in the soliciting section should be able to be prosecuted for soliciting. In other words, it is the person who makes the solicitation who can be found guilty of the offense, whatever the sex of that person may be, whereas the person who is the beneficiary of the solicitation, the person being solicited, should not be found guilty of an offense contrary to section 175.1 as presently constituted.
If I may just throw out some question to you, Peter. Is it your experience that there have been increasing numbers of charges against male prostitutes, or have the police not really acted in that area?
I think there have been an increasing number, particularly on Yonge Street in Toronto. There's an area, I think, from about College Street up to about Wellesley, which is sometimes referred to as the gay strip. And it sounds like a dance, but it's not. There's a number of homosexual prostitutes or hustlers, whatever you want to call them, in this area. And I've seen a number of more charges come out of this area since Hutt. And in addition, a lot of those people are charged with loitering. They seem to be a lot more pressing and persistent sometimes than females in conducting their business. And so I think you're going to see a lot more of this in the future as well.
Let me take you to another area for a moment. In preparing a case or a charge of keeping or permitting a common body house, do you often rely on reputation evidence? And could you explain briefly what it is and how you use it, and how important it's been in obtaining convictions in your cases?
Reputation evidence is evidence of the general reputation of a house or of a woman alleged to be a prostitute. It's an exception to the general rule that reputation evidence isn't allowed. it's important that it be a general reputation. For example, a police officer can't get up and say that I think such and such a premise is a bawdy house because so-and-so told me it was, or because I know they've got a conviction for that from 2 or 3 years ago, but the evidence has to be one of the general reputation in the community. It's very, very useful to a Crown, and I use it very frequently, particularly in cases, obviously, of keeping a common bawdy house. It seems rather odd that when one of the constituent elements that the Crown must prove, that the premises are a common bawdy house, that the Crown can prove this by presumption and almost beg the question. But it's an extremely useful technique for the Crown. And normally it's done just by calling several police officers or one police officer and qualifying him by asking him how long he's been working in a certain area of the city and how long he's been working with morality squad, and if he has any familiarity with a particular premise, and he'll say he has. And I'll ask him if this premise has a general reputation, and he'll say yes, it has a reputation as a bawdy house. And I'll ask him how he knows this, and he'll say, well, I've got to know a number of people in the community by working there, and it's common knowledge among them, and I see a number of prostitutes walking in and out, so I gather that's a general reputation. Then, of course, if he's asked, well, how do you know these women that are walking or in and out are prostitutes, that can be proven by general reputation as well. I suppose you could say, if you wanted, that he knows they're prostitutes because they're hanging around a common bawdy house. But fortunately, nobody said that. Their reputation as prostitutes can be established the same way. It's extremely useful in bawdy house cases, and it's also particularly useful in cases of living off the avails of prostitution, because there's a presumption. I think it's in 195(2), I think, that says that evidence that a man is in association with prostitutes or lives in a common bawdy house is prima facie evidence that he's living off the avails of prostitution, or something to that effect. And for that reason, it's extremely helpful. Almost, in some cases, it's almost all the evidence a Crown has that a man, in common jargon, a pimp, is living off the avails of prostitution. We normally call evidence from 2 or 3 police officers who say they've taken observations on this man for the past 2 or 3 weeks, and on such and such a night, they saw him walking down the street with 2 females, and I'll say, did you recognize those females? Yes. And how did you know them? Well, I knew them to be common prostitutes. And I'll say, well, how did you know that? And he'll say that's their general reputation in the area. And it may or may not be their general reputation, but I haven't seen many defense counsel get around this. It's evidence that's usually accepted quite readily by the courts. And it's not too difficult to qualify a police officer in this area, and it's an extremely useful tool for the Crown.
And does that relieve you from having to prove specific acts of prostitution?
You mean in a bawdy house
Yes.
case?
Would you rely, or can you rely solely on evidence of reputation?
I don't think I've ever seen a case where the entire prosecution has been based strictly on reputation evidence, but I will say that there have been cases, and probably some reported cases, where there's been perhaps only one actual observation of an indecent act on the premises, but that coupled with reputation evidence would be sufficient to constitute it as a common bawdy house.
What, in your opinion, would constitute an effective cross-examination of an officer purporting to give that kind of evidence?
I hate to tell you these things.
He's so reluctant.
Yeah. I think what a defense counsel ought to do is just be a little more severe in his cross-examination and cross-examine more closely as to the foundation of this officer's knowledge, that this is the general reputation. Sometimes he'll say, well, I heard it through other police officers, but I think he should be pressed very closely about when he first heard this and who told him this and how many different people hold this view, and exactly what the words used are when he heard the phrase used that it was a common bawdy house, whether or not people used that term or whether they called it a whorehouse or a brothel or what. And I think if they're pressed more closely, it may be that their evidence may crumble.
How about with respect to a qualification even to give reputation evidence?
Well, that as well, as I indicated, I try to qualify the officer by showing his familiarity with the area. In a case that just finished today, in fact, I see Rick Stern here, he was on it, a case involving a man by the name of Joe Martin, who ran some alleged bawdy house houses on Yonge Street. I had evidence of officers who were part of a task force assigned specifically to work on Yonge Street to investigate these body houses, and they were working there a lot of hours, virtually day and night, in plain clothes, and they walked the streets and they went into a lot of these places, and so they got to know a lot of the prostitutes and a lot of the shopkeepers and a lot of the people in the area. They practically lived on Yonge Street, and I tried to bring out this evidence through those officers that they had a lot of familiarity with the people, and had a lot of conversations with people generally, and I think this was sufficient to qualify them, and I think most judges would accept that evidence.
Okay. Lou, can you give us some ideas of what might be an effective route in terms of cross-examination of that kind of witness?
Well, I don't know about that, but I do have a Lord Birkenhead's story, if that's of any assistance. Some years ago, the late F.E. Smith was at a dinner party with a lady of some curvaceous dimensions. And during the course of the dinner, he leaned over and he said to her, "Excuse me, would you go to bed with me for $1 million?" And she said, "Absolutely." Well, time passed. About 10 minutes later, he leaned over and he said, "Would you go to bed with me for $50,000? She said, "Certainly." Time passed. About 10 minutes later, he leaned over. He said, "Would you go to bed with me for $1? She says, "What do you think I am, a whore?" He says, "No, we established that 20 minutes ago. We're just settling the price." I think that's a good indication of an examination for qualifying reputation. In terms of what you do with police officers, I would think that if a police officer gets in and says, "Tom, Dick, and Harry told me that that's a body house," I don't think that's admissible, quite frankly. It doesn't come outside the area of hearsay evidence, and unless he has some specific knowledge, the fact that somebody told him something, if closely questioned, I think would make the Crown's case crumble. I agree, however, with Peter, and I say this with the greatest respect to His Honor and any other judges that might be present. Judges do have a tendency to accept that sort of evidence. The reasons, I suppose, are historic in the sense that for many, many years, nobody bothered really questioning that sort of evidence. But I think if it came to the crunch, so to speak, and a test were made of it, much of that reputation evidence would not stand up. I think it's clearly to be distinguished from the type of evidence that arose in situations like the case of OAD, where the reputation of the premises was derived from the premises themselves. In other words, if you're in a gaming or a common betting house, for example, and the officer is there and he picks up the phone 20 times in his 10-minute stay there, and somebody is trying to place a bet, a different person on each occasion, and you find betting slips and you find the paraphernalia for it and so forth, that establishes reputation qua the premises themselves. But I don't think a police officer saying that in walking my beat, 10 people came up to me and said, "Joe's place is a betting house," is really sufficient. Because I don't see how it differs from hearsay in any other realm. And unless Peter can tell me of some particular exception of which I'm not aware, I don't know how the evidence goes in.
Well, I don't know either, but it normally does.
Oh, I agree with you.
I don't know if a gift horse in the mouth.
I agree with you. It depends what side of the table you're talking from. If it's the Crown side, she go in. If it's the defense side, well...
Maybe we can get some help from His Honor. Do you usually hear reputation evidence? Do you find it convincing? And what, in your opinion, would be an effective cross-examination of an officer such as Peter has described?
If such evidence normally goes in, I guess that classifies me as abnormal. I am concerned about the hearsay nature of such evidence. If I could be cited authorities which would make this sort of evidence an exception to the hearsay rule, then I would, and I query whether such authorities exist, but if such authorities were presented to me, I would then accept the evidence as required to do. However, there is a vast distinction between admissibility of evidence and weight of evidence. And because of the hearsay nature of such evidence, I would be inclined to give very little weight to it. I want to add another or dimension to this reputation area, however. Just as a person can have a reputation as, say, a prostitute, a building or a premises can have a certain type of character. And the Crown frequently introduces into evidence factual material to attempt to establish the character of a particular building which the Crown alleges is a disorderly house. One way that that is frequently done is by evidence of traffic to and from the premises. And a police officer will be stationed across the street in an upstairs room, and he sits there counting 1, 2, 3, 4, and at the end of the day he can determine that 83 people went in and that 83 people went out, and if pressed he can even give you the times right to the minute and second when this occurred. This evidence is frequently helpful to the Crown. It may not in itself give rise to any presumption taking effect, but it would tend to minimize or negative any assumption by the defense that this was a little old lady's rest home that no one ever attended. Sometimes the evidence as to the character of the premises, when added to other evidence which the investigating officers find at the time that a warrant is executed, would be enough to establish the guilt of the accused beyond a reasonable doubt. With respect to the last part of the question you asked me concerning what would constitute an effective cross-examination, I feel that the officer giving this type of evidence should be closely questioned concerning, to establish beyond any question that he had no personal knowledge of the matter and that all he knew was something that someone had told him, and further that he had made no investigation or taken any steps to attempt to verify what had been told to him.
I think we should turn to our last topic. We're running out of time, and it's been brought to my attention that we have in our audience a Constable Mace Armstrong from Project P of the OPP, and we are going to be discussing obscenity. And Peter has indicated to me that he has lectured to the Crowns, and I wonder whether this person might come up and join us. He's hiding. No, there he is.
He's over there.
We have
I don't want to
we'll
embarrass
grab
you,
a chair and please, come on up. Prefer
You
to
wanna
watch?
watch?
Fine. Okay.
All right.
You watching us for any particular reason?
He's also taking notes.
Keep your hands above the table.
Let us turn to the last area we're going to deal with tonight, which is to touch upon a few topics in the field of obscenity. I was going to turn it over to Peter for a moment to try to explain what the difference is between indecent, immoral, and obscene.
I can show you.
And in some of the sections, I'm sure he'll comment, the word is simply obscene, and then in others, it's that tripartite phrase, and then it goes on with the addition in one section of scurrilous. Could you perhaps enlighten us as to the significance and meaning of those?
Yeah. I don't want to indulge in a lecture on the law here because usually very dull, but where the terms are used together, indecent, immoral, or obscene, or particularly in section 163 of the Code, which refers to indecent theatrical performances. The section reads in part, everyone commits an offense who, being a lessee, etc., in charge of a theater, presents or gives therein an immoral, indecent, or obscene performance or entertainment. That section is normally used to catch the striptease type of situation that goes too far. The words have been held in that section to have different meanings, and an information would be multifarious if it charged all three. So the Crown has to pick one, as it were. There's some cases which suggests that they go up a scale, and immoral is at the lower end of the scale, indecent in the middle, and obscene at the higher end of the scale. Obscene in Section 163 probably has basically the same meaning as it has under Section 159, but there's no clear authority on that. The word scurrilous is also used from time to time. It's something that I haven't had a lot of experience with in court, and the meaning of it is rather vague. I think the ones that most lawyers would encounter in practice would be immoral, indecent, or obscene, one way or another. I tend to be consulted a lot by officers from the morality squad who are out seeing females dance and want to lay one of these charges and come to me to question which one they should lay, and it's my general which charge they should lay. It's my general advice after going out and making an inspection myself that they shouldn't lay any. That they should lay a charge of indecent performance, assuming the facts fit it. And the reason that is that it's my view that the term immoral is extremely vague and uncertain, and it would be very difficult for a Crown to establish that. So from a defense lawyer's point of view, if he's got a charge where that term is used, I think he could more easily be successful at a trial, because no one's really clearly defined or decided what the term immoral means. At the opposite end of the spectrum, there's a term obscene performance. As I say, the cases seem to suggest that that's the higher end of the spectrum, and it would take probably quite an extreme situation for the Crown to establish that a woman was guilty of an obscene performance. Usually when police find those, they don't tell anybody about them, I suppose. I instruct them normally to take the middle road and lay a charge of indecent performance, because there are a lot of authorities which attempt to define the term indecent, and that seems to be the most clear cut under the law.
Perhaps I can put a question to you. The definition of obscenity is set out in relationship to the distribution of publications or objects in 159 as the dominant characteristic of which is the undue exploitation of sex. And that's led to one definition of obscene through the case law. There is another common law definition set out in an 1868 case of Regina and Hicklin, which is the historic common law definition of obscenity. Do you have any opinion on whether the common law definition applies to obscene as it's used throughout the other provisions of the code, except for 159, which has its own definition?
I haven't seen any authority which applies that definition to the other sections, but my view is that it wouldn't apply, even though it still is the common law definition. I think courts would be more inclined to look at Section 159 or just make up their own mind as to what obscenity is under the circumstances. Of course, with respect to Section 159, the common law test in Hicklin, which was that the material has a tendency to deprave and corrupt, no longer applies at all under Section 159. My inclination is that it probably doesn't apply or wouldn't be held to apply under the other sections as well.
Okay. Turning then to the test, if I may ask Your Honor this question. The test as set out in 159 has been interpreted, as I understand it, and the question is the accepted standards of tolerance in the contemporary Canadian community. And you, as the person who must decide that issue, can you indicate some areas that have caused you difficulty or some questions you think counsel ought to deal with in dealing with those issues or that test?
There is no area in this part of the criminal code that has not caused me difficulty. The cases seem to indicate that the test that is to be applied is a national test, a national standard. And in this regard, our cases are completely opposite to the situation in the United States, where the courts have held repeatedly that each community, each city or town is to determine its own standard of tolerance for various questionable materials. Also in the United States, of course, all obscenity trials, or the vast majority of them, are tried by juries, whereas in Canada all of them are tried by judges sitting alone. The judges in Canada, therefore, are in an unusual and unique position of trying to set down or determine what a national standard is for obscenity. What would the average Canadian person tolerate within the community? And the judges, of course, are in a heads you lose, tails you lose situation if they hold that a particular book, movie, piece of sexual paraphernalia, etc., is obscene. Then they are accused of clamping down on freedom of expression and freedom of speech, etc. And if they rule that a particular item or items are not obscene, then the judge is accused of permitting or condoning salaciousness. So the judge can't win either way. How a given judge in a particular community who may not necessarily be widely traveled nationally is supposed to apply a national standard is beyond me. Furthermore, the standard, however applied, has to be a subjective one, and what might be shocking or obscene to one judge might not be so to another. You therefore have justice according to the tolerance of the individual judge. There is no objective, rigid standard for the courts to apply, nor for the members of the public to know so that they can conduct their activities and their daily lives so as not to breach the criminal law. Now, the problem was compounded very recently by the decision of the Ontario Court of Appeal in Regina and Sidey. I have the citation here somewhere. I'll fish it out in a minute. In the Sidey case, Judge Grayburn of the York County Court was hearing a case involving an exotic dancer charged with nudity in a public place contrary to Section 170 of the Criminal Code. And he determined on the facts before him that the dancer was not totally nude. Accordingly, Section 170, subsection 2 came into play, and that section read that the judge was to then consider whether or not it had been proven that the dancer in question was so clad as to offend against public decency or order. No evidence was called before Judge Grayburn as to what the community standards were, whereas it is very common in these cases that experts are called to give evidence as to community standards and community tolerances. No such expert evidence was before His Honor Judge Grayburn. And Judge Grayburn then ruled in a lengthy and well-reasoned judgment that in the onus was on the Crown to prove the applicable standard, and in the absence of any such evidence, the accused was entitled to be acquitted, and he acted accordingly. The matter was then appealed to the Ontario Court of Appeal, And in a recent judgment, Mr. Justice Holden, in a unanimous judgment of that court, indicated that I thought I had the citation here. It's in one of the recent editions of the Canadian criminal cases in any event. The Court of Appeal ruled that His Honor Judge Grayburn was wrong, and that while it would have been preferable had the Crown called the expert evidence referred to, in the absence of that expert evidence, Judge Grayburn was required to make a decision based on his own knowledge of the community and community standards concerning whether or not the performance by the dancer in question was indecent. And accordingly, the appeal was allowed and the matter was remitted back to a county court judge for a new trial and determination. Now, the judges, therefore, are left in a position where they are required to look at a particular book or photograph or magazine or movie, or they are required to listen to a recital of what a particular dancer or performer might have done on the stage. And then that judge, in some mysterious way, is supposed to determine what he thinks the standard is on a national basis for Canada and what the average Canadian person would tolerate, and he then is to determine, based on that, what whether or not the particular performance is obscene or indecent, depending on the section which is before the court. I find this contrary to all of my training. I have been trained for years that I was to decide cases based on the evidence and only on the evidence, and I was to reject from my mind anything which was extraneous to that evidence in coming to a conclusion. And now, contrary to all of that, I am told, forget that. You're now to reach into what your own morality or sense of conscience might dictate, and without any expert evidence before you at all. Mind you, if you have some expert evidence, so much the better, but if you have none, it doesn't matter. You're still required to make a decision concerning these standards. How the judiciary is supposed to do that escapes me, and how you are supposed to have any uniformity in decisions around our country in the face of such standard escapes me as well.
Okay. That, I understand, is our last question. We have been silent.
But I will take the chairman's prerogative for a moment to just comment on one case for clarification, and that was the case that Peter referred to before, case of Taylor. From a defense point of view, don't abandon the approach to the sequential type of persistent importuning, because the Court of Appeal in Taylor really didn't decide the issue. It was a summary conviction appeal brought from a decision of Judge Houston in the county court. What the Court of Appeal said, Mr. Justice LaCourse here, speaking for the court, was that an issue of law had not been raised, that His Honor Judge Houston had adverted to Hutt, had probably wrongly decided or applied Hutt in the circumstances, but they weren't prepared to interfere because they viewed it as a question of mixed fact and law, not a question of law. So the area is still open to be pursued in the higher courts. On behalf of everyone, it's of a dubious distinction to thank a panel for their expertise in the area of morals offenses, but I do thank everyone. And next week, conspiracy.